Hi, I'm Kerry Brooks. Welcome to this video presentation on the dangerous sirens of 35 U.S.C. 103. In this video presentation, I'm going to suggest that you not follow the literal wording that's in a portion of 35 U.S.C. 103 with respect to two terms and the way they're put together in a portion of the section of the statute. For some, this will be a hard teaching, as they say. They may reject this outright. Perhaps some have actually looked at 35 U.S.C. 103 and decided to follow the literal wording of that portion of the statute. Others may have adopted an approach to prosecuting patent applications handed down from their mentors over the years. And still others may be actually arguing a portion of 35 U.S.C. 103 without actually realizing it. Let's take a look at the statute. 35 U.S.C. 103 sets forth one of the conditions for patentability, and that's non-obvious subject matter. It's true that you have to look at all the words in a section of the statute, but you can't do that in a vacuum. You need to consider other sections that go along with it, and of course the case law that is developed while that section of the statute has been enforced. For example, consider 102, which sets forth a condition for patentability, and that is novelty. But 102 doesn't tell you the entire story. You have to go to 35 U.S.C. 103 to learn that a patent for a claimed invention may not be obtained, notwithstanding that the claimed invention is not identically disclosed as set forth in section 102. 102 doesn't say anything about the claimed invention having to be identically disclosed. You have to get that from 35 U.S.C. 103. So it's important to read all the words, but you have to take them in perspective. And if you follow the literal words here, and if you argue the differences between the claimed invention and the prior art, or similar approaches, it could lead to unintended consequences that are undesirable. Now, the statute drafters had to refer to something regarding the conditions for patentability under 103, and they chose the term claimed invention, which was added to 103 as part of AIA, and it was a substitution for, I believe, the subject matter sought to be patented in one location and subject matter in another location. Unfortunately, the drafters didn't use more precise language, and I'm not really sure what the exact precise language would be needed, but for example, they could have said something closer to the subject matter set forth in a specific claim under review. And that's because, as you will see in later presentations, that the term claimed invention is really not any better than that patent profanity, the present invention. Neither the claimed invention nor the present invention are directed to specific limitations in a specific claim. And as such, when they're used, they can be applied to all the claims in a patent or all the claims in a patent family. My suggestion is to avoid 103's alluring temptation to refer to the claimed invention in any way, anywhere. Chief Judge Markey left an everlasting mark on the meaning of obviousness under 35 U.S.C. 103. Judge Markey viewed all inventions as a combination of old elements because, in his words, only God works from nothing. Man must work from old elements. The term differences was in 35 U.S.C. 103 prior to AIA, and at times when great learned judges like Markey and Rich were judges on the CCPA and later on the Federal Circuit. I'm not aware of any case that Markey or Rich wrote, or anyone else, that says that the only way to establish obviousness or non-obviousness under 35 U.S.C. 103 is by arguing the differences between the claimed invention and the prior art. As a matter of fact, the Supreme Court and KSR suggest the opposite. The Supreme Court and KSR didn't throw down the teaching suggestion motivation case. It's still applicable, But they said it's not the only way of establishing obviousness or non-obviousness, and provided numerous guidelines on how to address that question. Now, I'll be talking about many ways in addition to the guidelines set forth in KSR to address the question of obviousness or non-obviousness without arguing the differences between the claimed invention and the prior art. But for the moment, consider focusing on errors in finding of fact or error in application of the law. The term difference is defined as a point or way in which people or things are not the same. The term differ is defined as unlike or dissimilar. The term different is defined as not the same as another or each other, unlike in nature, form, or quality. Now we're going to focus first on some of these similar type terms in the cases we're going to watch, but then we're going to extrapolate from that. We're going to see other terms and ways that somebody can be arguing the differences between the claimed invention and the prior art, perhaps not actually realizing that they're doing it. So it's my suggestion to avoid 103's alluring temptation to refer to the differences between the claimed invention and the prior art in any way, anywhere. The issue under 35 U.S.C. 103 is non-obvious subject matter. It's right in the title. The issue under 35 U.S.C. is not the differences between the claimed invention and the prior art, because there are many different ways to establish obviousness and non-obviousness under the statute. And if you stop and you think about it, all the limitations of a claim can be found in several different pieces of prior art. But that doesn't mean that the limitations in the claim are not still patentable, even though there's no differences. So my suggestion is to avoid commenting in the written description of the application and during prosecution on differences between the claimed invention and the prior art. Now, the next few video presentations will involve cases finding a disavowal of claim scope triggered by simple words and phrases, alerting the reader to differences between the claimed invention and the prior art. For some, the next few cases may be stepping stones towards understanding much more subtle words, phrases, and elements of grammar that can lead to certain types of disavowals of claim scope. Thank you for watching this video presentation, and I really do hope you take the time to watch the follow-up cases and video presentations, because I think they really may be helpful. Thanks for watching.